we represent parents who have been falsely accused of abuse or neglect. We represent these parents in criminal court, but we also represent them in juvenile court and divorce court, where custody rights are at stake. These cases are emotionally heart-wrenching, and our sympathy goes out to any parent who's embroiled in these circumstances. These cases usually begin with an accusation being made by a spouse or an ex-spouse who suspects abuse, or by a child who reports abuse to a sibling, teacher, friend, or parent. There is almost always a motive behind these false allegations. The motive is generally to change custody or visitation. An immediate change in custody of the child or children can be done by a parent filing a petition with the family court without the knowledge of the other parent. In this way, the party obtains a temporary restraining order by swearing out an affidavit alleging domestic violence, child abuse, or child neglect. These applications are rarely denied. Temporary restraining orders, also known as TROs, may accompany a petition for dissolution of a marriage if the parents are not yet divorced. The restraining order becomes effective immediately after the judge signs the order. In a petition of dissolution of marriage, these orders almost always require the accused parent to move out of the home and place temporary custody of the children with the spouse who filed the TRO. In cases where the parties are already divorced, the TRO changes custody or visitation arrangements, placing temporary custody with the parent who filed for the TRO and cutting off visitation with the other parent. In cases where the parties are already divorced, the TRO is then followed up by the other party with an order to show cause requesting the court to conduct a hearing to decide if a change of custody or visitation should be permanent. Parents are usually served with a TRO by a law enforcement officer. If you own any firearms, you are almost always required to surrender them to your local police station or the licensed gun dealer to have them sold. You do not get them back unless the court orders them returned to you. A parent served in this way must file a response to either a TRO or an order to show cause within the time set on the notice. This can be a very short period of time. In the case of a TRO, after the response is filed, the parent is then required to appear at a hearing to determine if the TRO should be extended until the court determines what custody and visitation orders it will adopt following a trial. It is critical that your attorney prepare a response that addresses the allegations made by the other party. This sets the tone for all future interactions with the court and with the ex-spouse. In this context, it is especially important to remember that whichever party puts on the best show wins. Nowhere is this more important than in cases of false allegations. That's because the falsely accused parent always starts in a negative position. The first time a judge hears about the parties is usually due to the false allegation itself. For this reason, the falsely accused parent is immediately put in a negative position. Often at the same time as a petition for dissolution of marriage or for a modification of custody, a request for child support and often spousal support will be made. The amount of child support a parent is required to pay is based on a convoluted and rigid mathematical formula that the state legislature adopted. The calculation requires a computer called Dissomaster. On top of the state-mandated support rates, falsely accused parents may be asked to pay for the ex-spouse's attorney fees and to pay add-ons such as therapy fees, etc. It is critical in the false accusation context to have a legal team to help keep these add-ons under control. In California, parties must participate in mediation regarding child custody and visitation issues. The mediators work for the court. Sometimes, but rarely, mediators can work out visitation and custody arrangements satisfactory to both parties. If mediation does not result in a settlement, expensive discovery and trial preparation are next. In new dissolution cases involving child custody and visitation, the court may be inclined to bifurcate the case. This means having two trials, one regarding the child custody, support and visitation issues, and the other having to do with the division of community and separate property. In a contested case, if mediation fails, the process of discovery begins. Each side sends the other a list of questions called interrogatories. These are questions drafted by the lawyers, and they must be answered under oath. Interrogatories are composed of questions about finance, assets, pensions, and similar financial issues. Through discovery, the spouses can ask the other to produce documents such as bank statements, credit card bills, paycheck stubs, receipts, tax returns, etc. The lawyers can then ask questions of the spouses in person under oath at what is called a deposition. A deposition takes place in the presence of a court reporter, who later transcribes what is said into a typewritten transcript. Other people who have important information, accountants, friends, relatives, and neighbors, may also be questioned at a deposition. In divorce depositions, lawyers are typically looking for hidden assets and to determine how much money, earning power, and other assets each spouse has or had so that they can properly divide the property. In custody cases, the lawyers look for evidence that the other party is not the best parent to have custody. Whether a falsely accused parent ultimately settles the case or litigates it to the bitter end, trial preparation is essential. Trial preparation is important because the information that comes out of a trial depends upon how well the attorney understands and presents the client's position to the judge. The best case can be lost if the lawyer is careless, incompetent, ineffectual, or unprepared. In addition to being ill-equipped for a possible trial, the unprepared lawyer cannot negotiate a settlement from a position of strength. Especially in the false allegation context, one of the most important parts of preparing for trial is obtaining the right expert witness. An expert witness is someone who is allowed to express a professional opinion at trial. In custody cases, expert witnesses include psychologists, social workers, therapists, and pediatricians. In custody cases, the court will often allow testimony by psychologists or social workers to help determine what decisions are in the best interest of the child. Expert witnesses like psychologists usually charge $150 to $300 per hour to evaluate the people involved and formulate an opinion regarding who should be granted custody. Our litigation group has a strong working relationship with the best expert witnesses in this important area. Once the discovery process is complete, the attorney must use legal precedent to build an argument about what the client is entitled to and why. A trial will then take place during which the lawyers will present the judge with information favorable to their arguments. The trial itself will proceed in front of a judge and will begin with each lawyer making an opening statement describing what he or she intends to prove. The judge hearing the case will decide each issue. After the trial, if either party is not happy with the results, either party or both may appeal. Remember, in this context, whichever party puts on the best show wins. A falsely accused parent must have an experienced and well-prepared team to deal with not only divorce and custody, but with the potential for criminal prosecution of the same allegations, possibly even during the same time period. That is why we always consider the potential for criminal prosecution in every false allegation custody case. We make sure not to do anything in the custody case that would jeopardize the client in some subsequent criminal court.